Picture your family 6 months after you're gone. The house is still in your name. The accounts are frozen. The mortgage, taxes, and insurance are still due every month. And somewhere between 3 and 7% of everything you've built is being consumed by court costs, attorney fees, executor fees, and administrative expenses before your family sees a dollar. That's probate in Ohio. On a $1 million estate, that often means $30,000 to $70,000 of probate-related costs and 6 to 12 months of delay, sometimes longer. And most of it is avoidable if you understand how probate actually works and you take a few deliberate steps while you're still living. This video shows you exactly how to do that. I'm Andrew C. Goodwin, the principal attorney at Rhodium Law. I help Ohio professionals, business owners, and their families build estate plans that protect what they've worked a lifetime to build. This topic is personal for me. I didn't set out to be an estate planning attorney. After 15 plus years in IT, I spent most of my legal career at a large law firm and then as in-house counsel at a global health system, drafting, reviewing, and negotiating complex commercial agreements. But in the early days of the pandemic, I noticed changes in my mother, her memory, her ability to take care of herself. I had watched my father go through his own dementia journey years before, and I recognized what was coming. I stepped away from my career goals to become my mother's full-time caregiver. I did that for 5.5 years. During that season, I found out what it actually cost the family to be unprepared, legally, financially, emotionally. I couldn't find the right legal counsel for my own family, so I learned estate planning and elder law the way nobody wants to learn it, from the inside, all while trying to hold everything together. That experience is why I built this practice, and it's why I'm making this video. Before we talk about how to avoid probate in Ohio, let me walk you through what it actually is. Most people have heard the word. Very few know what the process actually looks like. That gap is the first problem. Probate is the court-supervised process your estate goes through after you die. It exists for one reason: to transfer your property from your name into the names of your heirs under the oversight of a judge. The court confirms your will is valid, inventories what you owned, settles your final debts and taxes, and then distributes what's left. It sounds simple. In practice, it's time-consuming, procedural, and in many cases, expensive. Here's what the Ohio probate process actually looks like, step by step. Step 1, someone typically named the executor in the will, files the will and a petition to open an estate with the probate court in the county where the person last lived. Each Ohio county has its own probate court. Filing fees apply from the start. Step 2, the court issues letters of authority. This is the document that legally empowers the executor to act on behalf of the estate, to access accounts, sell property, pay debts. Nothing can be touched until those letters are issued. Depending on the court, that process can take several weeks. Step 3, the executor prepares and files an inventory of every asset: the house, retirement accounts, bank accounts, vehicles, investments, personal property. Creditors are formally notified. They have a window to file claims. Debts get paid, disputes get resolved. Step 4. After creditors are satisfied and taxes are addressed, the executor distributes what remains to the heirs named in the will. If there is no will, Ohio's intestacy statute, Ohio Revised Code, section 2105.06, decides who inherits and in what proportions. Step 5. The executor files a final account with the court. The court reviews and approves it. Only then is the estate formally closed. From start to finish, a straightforward Ohio estate typically takes 6 to 12 months at a minimum. Contested wills, unclear asset titling, disputes between heirs, or a complicated asset mix can push that well beyond a year. Throughout that entire window, your family is waiting, and the bills do not wait with them. Now let's look at the cost. Probate in Ohio does not follow a fixed percentage, but when you combine attorney fees, executor compensation, court costs, appraisals, and administrative expenses, it is common for total costs to land in a range that can approach somewhere between 3 and 7% of the gross probate estate value. That's not a precise formula. The exact number depends on the estate's size and complexity, the county, and the professionals involved. But 3 to 7% is a working range Ohio attorneys and financial planners use for Ohio estate planning. And it comes out of the estate before your heirs receive anything. Here's what that range looks like on real Ohio estates. On a $500,000 estate, paid off home, and a modest retirement account, which is not unusual for Ohio professionals in their 40s or 50s, the probate cost generally falls somewhere between $15,000 and $35,000. On a $1 million estate, which many Ohio professionals reach by their 60s, between a home, funded retirement accounts, and life insurance, that range is generally $30,000 to $70,000. On a $2 million estate, a long-term saver, a business owner, or a professional with multiple assets, you are looking at a range of $60,000 to $140,000. None of that money goes to your family, and the people who are most diligent about building something may end up inadvertently leaving their family to absorb costs that were entirely avoidable. I want to be specific about Ohio because a lot of estate planning content online treats every state the same. Ohio is not every state. There are 3 things about Ohio's probate system that make it particularly important to plan ahead. First, Ohio has not adopted the Uniform Probate Code. The UPC is a streamlined, standardized probate framework that some states have adopted to simplify and accelerate the process. Some states use UPC-style systems that allow more informal probate with less court involvement. Ohio uses a more traditional court-supervised process. That often means more filings, more oversight, and less flexibility in how estates are administered. Second, Ohio's intestacy formula is somewhat rigid, and it does not account for the reality of modern families. Under Ohio Revised Code, Section 2105.06, if you die without a valid will and you have children from a prior relationship, your surviving spouse may not inherit everything. The statute applies a fixed formula, a portion to the spouse, a portion to the children, regardless of what your intentions would have been. For blended families, that can create outcomes most people would never choose if they understood the rule ahead of time. Most remarried couples have no idea this formula exists until they sit across from an attorney for the first time. Third, Ohio requires a formal inventory and a formal final account for most estates. Some states allow simplified administration for small estates. Ohio does have a summary release from administration, but the asset thresholds to qualify are somewhat low. Most Ohio professionals who own a home titled only in the name of the person who passed away may not qualify. Put those together, and the takeaway is simple. Ohio does not make probate avoidance automatic. If you want your family to avoid it, that outcome requires planning ahead. Now, the part this video is actually about. There are 3 real mechanisms Ohio families use to keep their estates out of probate. They're not loopholes, they are legal tools the state of Ohio expressly recognizes. And for most Ohio professionals, the answer involves using more than one of them. Strategy 1. Beneficiary designations in Ohio TOD or POD titling. The first and simplest strategy is making sure every asset that can legally pass outside of probate actually does. Retirement accounts, 401ks, IRAs, pensions pass directly to the named beneficiary on file. Life insurance does the same. Bank accounts can be structured as payable on death or POD. Investment accounts can be set up as transferred on death or TOD. Here's where this breaks down in practice. Most people assume their beneficiary designations are current. A significant portion of them are not. When I review beneficiary designations with a new client, outdated forms are a common finding. Former employers, ex-spouses, relatives who have passed away. Accounts opened years ago with blanks never filled in. The designation that was accurate in 2009 may be a serious problem today. An action step worth taking this week: pull your beneficiary designations on every retirement account, every insurance policy, and every bank and brokerage account. Review each one. Make sure the named individuals are who you intend. Ohio also recognizes a specific instrument called the Transfer on Death Designation Affidavit for real estate. This is an Ohio-specific tool that allows you to name a beneficiary for your home directly on the deed. When you pass, the title transfers automatically. No probate, no court filing, no waiting period. It is a straightforward tool, but it's not the right fit for everyone. Strategy 2. Joint ownership, what it solves and what it doesn't. The second strategy is joint ownership with rights of survivorship. In Ohio, when 2 people own an asset jointly with survivorship rights, the asset transfers automatically to the surviving owner at the first death. No probate, no court process. This is the most common way Ohio married couples handle the first death. The house is titled jointly. The bank accounts are joint. The surviving spouse inherits them immediately and continues without interruption. 2 caveats worth understanding clearly. First, Joint ownership only solves probate at the first death. When the second spouse passes, unless additional planning has been done, those assets still need to go through probate to reach the next generation. The problem is deferred, not eliminated. Second, adding a person as a joint owner of an asset exposes that asset to their creditors, their divorce proceedings, and their legal judgments. In particular, adding an adult child to a property deed to avoid probate may expose your home to the risk arising from your child's financial and relational situation. This is a strategy I recommend thoughtfully, not as a reflex. Strategy 3. A properly funded revocable living trust. The third strategy, and the one that handles the widest range of situations cleanly, is a properly drafted and properly funded revocable living trust. Here's how it works. You create a legal entity called the trust. While you are alive, you transfer your assets into that entity. You serve as your own trustee. You can buy and sell assets, change beneficiaries, and revoke the trust entirely if you choose. Nothing about your day-to-day life changes, but your assets are now owned by the trust, not by you personally. When your night comes, as we like to say at Rhodium Law, there's nothing in your individual name for probate to touch. Your successor trustee steps in and distributes the assets to your beneficiaries privately without court involvement. Private, faster. No frozen accounts, no public court record of what you owned or who received it. The word that makes or breaks the strategy is funded. A trust that has been drafted but never funded, meaning your assets were never retitled into the trust name, is a legal document sitting in a drawer. It does nothing at your death. Your family still ends up in probate because the trust was empty. Drafting the trust is step one. Funding the trust is the step that actually does the work. One study indicated that approximately 58% of families who experienced disputes after a death had no comprehensive plan in place. A properly structured and funded trust removes much of the ambiguity that produces those disputes. For most Ohio professionals, the most complete approach combines all three strategies: beneficiary designations on retirement accounts and insurance, joint ownership handled carefully during marriage, and a fully funded trust as the primary instrument for everything else. Before I close, let me answer the two questions I hear most often when this topic comes up. Question 1. Do I really need a trust, or can I just use beneficiary designations for everything? For some people, beneficiary designations are genuinely sufficient. If your situation is simple, one spouse, no minor children, no blended family, no real estate, no business interests, no complicated assets, you may be able to keep your estate out of probate through designations alone. But for most of the Ohio professionals I work with, a funded trust does more. It handles incapacity planning while you're still living, not just what happens after you are gone. It also handles assets that cannot easily carry a beneficiary designation. The trust is not just about your death. It is about continuity of management across any event that takes you out of the decision-making seat. Question 2. If I set up a revocable trust, will the IRS treat me differently? During your lifetime, no. A revocable living trust is generally treated as a pass-through for federal income tax purposes. You report income the same way you always have. Your tax return does not change. The IRS sees you and your revocable trust as the same taxpayer. Tax complexity begins when you move into irrevocable trust territory, and that is a separate conversation for a later video. I want to leave you with one way of thinking about what we covered today. Ohio probate is the toll booth at the end of the road you spent your life building. The toll booth does not care how hard you work to build the road. If you do nothing before you arrive at the toll booth, your estate goes through it by default. Estate planning is how you take a different exit. You see, you spent decades earning, saving, paying down your mortgage, funding retirement accounts, building a business, accumulating the things that matter, the relationships that matter. That road has real value. And at the end of it, if you have not made 3 specific decisions, there is a toll booth waiting. 3 to 7% collected by the system before your family inherits what remains. 6 to 12 months of waiting before the assets they may need are accessible, and a public record of everything you owned and who received it. Beneficiary designations and Ohio TOD, POD instruments take individual assets off the road before the toll. Joint ownership handles the first death transfer without stopping, and a properly funded revocable trust reroutes the entire estate so that the toll booth is never even reached. None of these are complicated. All of them require being deliberate while you are still in a position to act. Most people watching this video already have enough assets for this to matter. They just haven't taken that next right step to get their plan in place or to update it. Please remember, the best estate plan is the one you finish correctly before it is needed. If you're building a life that you want to protect, subscribe. I break down Ohio estate planning in plain language so you can make informed decisions before it's too late. I publish a long-form video every week on Ohio estate planning topics, all focused on what Ohio families actually need to know. I've also put a free resource in the description below. It is called the Ohio Probate Trap. It covers what happens to your home, your retirement accounts, and your family when there is no plan in place. It is free, no credit card required. Just click the link. One last thing, I am an attorney, but watching this video does not make me your attorney. This video is merely general information and does not constitute legal advice. If you are ready to put an estate plan in place or to update one that no longer reflects your current life situation, please contact an attorney who will review and discuss your specific circumstances. Strategize, secure, shine. I'll see you soon.